Welcome, everyone. Thank you for joining us today for this discussion of yesterday's Supreme Court ruling in the case of West Virginia versus EPA, which looked at how broadly the agency should be allowed to develop emissions limitations for power plants. In the case, a group of attorneys general from West Virginia and other Republican states, together with the coal industry, argued that the Obama administration's Clean Power Plan, which would have mandated that power plants reduce their emissions by 32%, below 2005 levels by 2030, relied on an overly broad interpretation of the Clean Air Act and gave the EPA what they called excessive and industry transforming power. The Biden administration and other supporters of the regulation argued that this case was about a regulation that does not exist, that never took effect, and which would have imposed obligations on the energy sector that it would have met regardless. Now, in its ruling, the court said that while the EPA can regulate power plant emissions, the agency can't try to shift power generation away from fossil fuel plants to cleaner sources. Writing for the 6-3 majority, Chief Justice John Roberts said, Congress needs to speak more explicitly to give an agency that much power. Quoting him now, capping carbon dioxide emissions at a level that will force a nationwide transition away from the use of coal to generate electricity may be a sensible solution to the crisis of the day, but it is not plausible that Congress gave EPA the authority to adopt on its own such a regulatory scheme. Writing the dissent for the three liberal justices, Sonia Sotomayor said the majority was constraining the federal government's ability to address carbon emissions during a time of crisis. She wrote, the subject matter of the regulation here makes the court's intervention all the more troubling. Whatever else this court may know about, it does not have a clue about how to address climate change. And let's say the obvious, the stakes here are high. Yet the court today prevents congressionally authorized agency action to curb power plants' carbon dioxide emissions. Justice Elena Kagan warned that the court appoints itself, instead of Congress or the expert agency, the decision maker on climate policy. I cannot think of many things more frightening, she said. We've assembled a great panel today to unpack all of these issues. First, Andres Restrepo, who's a senior attorney at the Sierra Club, will give us more on the background and legal context for the decision. Next, Rachel Cletus, who is the policy director of the Climate and Energy Program at the Union of Concerned Scientists, will discuss the implications of the court's decision for domestic climate and energy policy and US commitments under the Paris Agreement. Finally, Michael Gerard, who is founder and faculty director of the Sabin Center for Climate Change Law at Columbia University, will review the options for continued US domestic climate action, including at the EPA. And after the three of them have made their opening remarks, we'll turn to all of you for your questions. You can put your questions in the Q&A section in the chat, not in the chat, in the Zoom call. But before turning to Andres, let me review why this ruling is so important. Power plants are the second largest source to transportation of US carbon emissions today. And of course, decarbonizing the power sector is also a linchpin of economy-wide efforts to cut emissions through electrification of energy use for transportation, in industry, and in residential and commercial buildings. The court's ruling is a significant blow to the Biden administration's ability to achieve its goal of decarbonizing the electricity sector and to achieving the US commitment under the Paris Agreement to reduce GHG emissions by 50 to 52% below 2005 levels by 2030. One of our speakers today, Rachel, argues the decision is also harmful in a broader sense because it goes to the heart of federal agencies' abilities to interpret existing laws based on the best available science and then to set robust standards accordingly. She's noted that once Congress passes protective laws like the Clean Air Act, agencies have generally had deference to implement those laws based on the latest scientific evidence of harms caused by pollutants and options to limit those harms. But with this decision, she said, the Supreme Court has hamstrung that authority. Others have expressed concerns that the ruling could have sweeping consequences for the federal government's ability to set standards and regulate in other areas, such as consumer protections, banking, workplace safety, and public health. But another one of our speakers today, Michael Gerard, notes that the ruling doesn't undercut EPA's other authorities to regulate greenhouse gases, such as imposing limits on motor vehicles, factories, and oil and gas production, and that EPA has other tools to control pollution from coal-fired power plants, which could include requiring efficiency upgrades, the addition of carbon capture technology, and changes in the fuel use at the plant, such as co-firing with natural gas. For its part, the EPA said it's reviewing the court's decision and is, quote, committed to using the full scope of its existing authorities to protect public health and significantly reduce environmental pollution. And of course, in addition to the EPA, the administration, congressional Democrats, and the US climate movement have all said they will continue to push vigorously for major climate legislation in the Congress and to work with states, companies, investors, and others to ramp down carbon pollution. So with that background, Andres, let me turn it over to you for your opening remarks.
Great, thank you, Alden. Thanks also to Rachel and Michael for being also on this panel, and to all of you for attending. So I agree with Alden, absolutely. This case is certainly a blow. It was a huge disappointment, and fundamentally, it takes off the table what had been EPA's most efficient and effective regulatory tool for reducing carbon dioxide pollution from existing fossil fuel fired power plants. One thing that I do want to note, though, because I have heard especially some concerns internationally, I just want to clarify, this case did not strip EPA of its authority to regulate greenhouse gases more broadly. I know there's a lot of international concern about that. The agency still has authority over greenhouse gases. That was established in a Supreme Court case 15 years ago. The court has not overturned that. It didn't even suggest that it was going to. So the agency still has that authority. And not only that, it still has, and Mike will talk a little bit about this later, it still has the legal obligation to reduce carbon emissions from existing plants. That's not even an option not to do that. The problem with this case is that the most effective way for doing that through federal regulations for EPA would be to set the stringency of those carbon dioxide targets on, to link it to the ability of the power sector to shift electricity generation away from fossil fuel fired units and towards renewable energy. That is how utilities and power plant owners have already been achieving remarkable reductions in CO2 from this sector for years. And it's by far the lowest cost and best way and of achieving those reductions, and the way that you can achieve the most significant reductions through a reasonable cost. So this decision takes that option off the table, and it requires EPA, in setting their carbon emission standards, to look only to the kinds of technologies and practices that can actually be integrated into each individual source, rather than considering the electric system as a whole and the availability of renewable generation. So that's, of course, a big setback. It means that the agency is going to have a more difficult time establishing nationwide limits on carbon pollution from these sources. And then another issue that I think will also, some of what I say may overlap with what Rachel and Mike will say, but one of the concerns that Alden touched on is that this case will likely have implications that go beyond just the electric sector. And the reason for that is that the justices decided this case through the lens of what's called the major questions doctrine, which is a legal principle that has been increasingly showing up in cases at the Supreme Court and otherwise, that requires federal executive agencies in the United States, like EPA or the Occupational Safety and Health Administration, the Food and Drug Administration, things like that, to, if they are planning to, or if they have an intention of issuing an agency regulation or taking some sort of action that would have major or important economic or political consequences, the court will essentially require the agency to point to some sort of explicitly clear and unmistakable authority in the governing law passed by Congress in order to undertake that action. So that means that if the statute is not absolutely crystal clear in pre-authorizing that action, a court will likely prevent the agency from doing that. Now, how important the regulation has to be, or how consequential it has to be before it reaches that, before it triggers that doctrine, is not clear. It's undefined. But I think the biggest concern we have here is not so much that there is a direct precedent from this case that will wipe out all these other regulations. The concern is that this will embolden opponents of public safety, health, and welfare regulations from all kinds of agencies to challenge those in court on the basis of what's called this major questions doctrine. And it will likely give the green light to judges who are skeptical of agency power to increasingly adopt this doctrine and strike down agency regulations that have important impact on our public health and welfare. And so that's I think the biggest concern, is that we're going to see an emboldened actions and challenges to agency regulations that, from our perspective, and from I'm sure those of Rachel's and Mike's organizations, are critical to protecting society. So that's really the downside of this case. You know, and I'll just say just another couple of words though. I want to note that, you know, this is not this EPA this decision from the Supreme Court is not going to suddenly and automatically change things on the ground tomorrow. I mean, that's what we've seen with, I'm sure you've all seen the Dobbs decision, which overturned Roe v. Wade, is having immediate impacts all across the country in terms of laws that are suddenly springing into effect. As it happens, there have actually never been regulations under this particular provision of the Clean Air Act, Section 111D. There have never been carbon dioxide standards for power plants that have actually taken effect. The Obama administration issued the Clean Power Plan. That was put on hold by the Supreme Court, never took effect. The Trump administration's replacement rule, which would have done nothing anyway, also never took effect. So plants are not going to suddenly be able to emit more pollution than they had yesterday or the day before that because of this ruling. You know, as I mentioned before, there has been a remarkable transition away from fossil fuel fired electricity, specifically coal fired electricity, in this country in the last 5 years, 10 years. That has gone on through many things, but the fundamental economics of the electricity sector has changed. Renewable energy is vastly more affordable than it used to be. It's much more competitive than even existing fossil fuel fire infrastructure in most of the country. And that transition has happened even in the absence of EPA regulations. It's happened through advocacy of groups like ours. It's happened through public utility commissions realizing that this is a better bet for consumers to go towards renewable energy, from utilities realizing that it's in their interest to transition. So we are continuing to see progress, and we will continue to see progress. Of course, this is exactly the worst time to take away tools from the federal government, which is what the Supreme Court decision did. And that's why it's such a big setback. But it does not mean that there is not going to be emission reductions that are going to be happening. That's going to be happening anyway. And, you know, the agency and state level governments and other organs of the federal government will continue to use everything in their power. You know, we're going to do all that we can to make sure they use everything in their power to keep that transition and moving forward. And with that, I'll let the next speaker take over.
Thanks very much, Andres. I think it's important, especially for our international audience, to have put this in context that, well, this is not a helpful decision and will be harmful, as Rachel will talk about, to both our domestic and international climate objectives. It's not as bad as perhaps it could have been. It could have undercut the entire authority from EPA in the Massachusetts versus EPA decision to regulate greenhouse gases at all. So Rachel, with that context, why don't you take us a little deeper on what this does mean, both for domestic achievement of the 2035 decarbonization target and also for the US international commitments under Paris.
Thank you so much, Alden, and thank you all for being here. Anders, you've set us up really well with that overview. I'll just continue in the same theme that this is no doubt a very bad decision. It's a blow. And it's a blow not just uniquely because of what happened in the Supreme Court decision yesterday, but because of the overall trend and context within which it happened as well. And part of that is a reconciliation bill that stalled in Congress, still not lost, but stalled for months. And we're watching every branch of our democracies sort of struggle to meet the moment when it comes to climate change. And that is a tough reality. That said, I do want to emphasize that all is not lost yet. And I'm going to just walk through a little bit about what else is happening around the country. And it's a mixed bag, no doubt, but there are some bright spots. So as Amber said, yesterday's decision significantly harms EPA's ability to set these strong carbon pollution standards for power plants. And I want to be very clear, what the court did was hamstring the EPA in how it can set standards, what it can include in setting standards. That doesn't preclude utilities doing whatever they want to do or states doing whatever they want to do to meet EPA standards whenever they emerge. And that's an important distinction. But we know that these power sector emission reductions in particular are very critical to meeting those US 2030 goals that Alden mentioned, that 50 to 52% below 2005 levels. The power sector has the most opportunities for near-term cost-effective reductions. It's also the linchpin for reducing emissions throughout the economy, electrifying transportation, buildings, industry, et cetera. So this is, even though overall it's the second leading source of heat trapping emissions in the US, transportation has overtaken the power sector. It is the linchpin, especially for these near-term emission reductions. Now, as has been emphasized, the court did not strike down EPA's authority to regulate heat trapping emissions. And EPA must move and is already moving on some other regulations. The power plant ones had not yet proceeded. We're expecting to see a proposal by March 2023 on the power plant regs. But they have started to move on vehicle regulations, and they are also going to be moving on methane regulations. Those two are very, very important. And if we get strong rules there, and that still remains to be seen, the initial proposal around some of the vehicle regs have been weak. If we get strong final rules there, those are very, very important near-term sources of emission reductions. Now, I should also mention that there are lots of reasons to turn down uneconomic coal. It's already happening in the marketplace, but not fast enough by any means. And the one major reason is they impose a tremendous public health burden on communities, especially Black and brown communities and low-income communities around the country. These public health burdens are underpinning a range of additional non-CO2 pollution standards that the EPA has underway and is going to undertake over the next year. That includes the Good Neighbor Rule, ozone and particulate matter, NAAQS, mercury rules, and together those could also lead to a shift away from coal to cleaner, less polluting resources to cut those other pollutants. One reality that we do have is that the market is driving a trend away from coal to cleaner sources, but also towards natural gas. And that is a big threat right now. If we continue to see a business as usual build out of natural gas, that is a big threat to meeting 2030 goals, not just because gas itself is a fossil fuel, but also because of methane emissions associated with it. And that's why those methane regulations on the oil and gas industry are going to be critical. As you might also know, the EPA has finalized a rule on HFCs, and this was in response to legislation that was passed by Congress in a bipartisan manner in December 2020. EPA then moved in 2021 to finalize this rule, and it's basically going to cap and phase down the production and consumption of HFCs in the US. And this is part of a global effort to phase down HFCs that, when it succeeds, can help avoid up to a half degree of global warming by 2100. Here in the US, we're going to see an 85% reduction over the next 15 years as mandated by the legislation that was passed in Congress. As Alden and others mentioned, there's also state and local action happening. States are continuing to embrace more and more renewable energy because it is one of the cheapest form of energy in many places right now. For example, we're seeing record scale up of solar energy and wind energy around the country. The EIA says that by the start of June, the power sector here in the US will see a 31% increase in solar capacity year on year, this June to last June. And almost a third of this is going to be built in Texas. Texas has tremendous wind and solar power. It has been actually a source of increasingly contributing to grid resilience in Texas. For example, during a heat wave that they had in May this year, it was wind and solar that really bailed out the Texas power grid, as many news reports showed. There's also going to be a 12% increase in wind capacity this June, year on year, with respect to last June. So really a tremendous build out, but not happening fast enough. And that's what I want to emphasize. The market on its own is not going to solve this problem. We do need policies. We need robust policies, and federal policies are key in addition to what's happening at the state and local level. There are actions also happening related to integrating more renewables onto the grid. We're seeing FERC step up in this space. We're also seeing regional grid operators like MISO start to undertake actions to help integrate more renewables. And this will be a really important piece. As we know, getting more renewables and cleaning up the power sector is not just about the end resources, but also making sure that we have the transmission to deliver that. The infrastructure bill that Congress passed last year, bipartisan infrastructure bill, does include some provisions around transmission investments. It also has some provisions around electric vehicle charging infrastructure. Those are important, and we're starting to see that money from the infrastructure bill start to flow out. DOE is implementing several programs. But just to be clear, this is not the climate bill we need. It is not on the scale that was necessary. And a lot of the investments in that bill are more pedestrian, business as usual kinds of infrastructure, not low carbon infrastructure. So the other big piece out there right now is a reconciliation bill, which has been stuck in Congress for months. We hear that there's progress behind the scenes. That bill needs to pass. It has some critical clean energy tax credits in it that can help accelerate the clean energy momentum that's already underway. It has other very important climate resilience, environmental justice, and jobs provisions, all of which will make for a package that will be hugely beneficial to the American public. That bill needs to pass this year, and actually before the end of this congressional term. There are some other prospects around the horizon. There are some rulemakings from the SEC around climate risk disclosure that can force fossil fuel companies to be held more accountable for their emissions. We have a number of private sector companies making net zero pledges. Now, what's critical though is that they need to step up and make near-term absolute deep emission reductions. These sort of hazy 2050 net zero pledges are not enough. So there's no question, the overall landscape is sobering. There are some bright spots. We need to accelerate those bright spots. Really, we're running out of time here. There's very little room to turn the ship around. Our 2030 climate goals are going to slip out of grasp if we don't make significant progress in the next year or two. That's going to mean no stone unturned throughout the federal government, at Congress, at state and local levels, private sector. We're going to need an all-in approach if the US has any chance of meeting those 2030 goals. Right now, we're very far off track. And meanwhile, we're seeing climate impacts accelerate alarmingly around the country. We're in what we're calling danger season for the summer here in the US, where we're seeing heat waves and droughts and wildfires, hurricane season that's expected to be very active. This is, a crisis for sure. And I just want to say we didn't get here by accident. The fossil fuel lobby and its political allies are responsible for blocking progress at every turn. They've been prioritizing their profits over the health and well-being of our nation. And climate change is not the only issue in their crosshairs. We're seeing the very fundamental aspects of our democracy being challenged, our policy-making process being challenged. And so getting that climate win is going to involve standing up to these forces that are opposing progress. Elections matter. We have an election coming up in November this year in the United States. It's going to be really important for the American public to show up because poll after poll shows that a majority of the American public understands the urgency of the climate threat, wants a clean energy transition. This has to be an election issue where people show up in support of it. And then on the final thing I want to say on the international front, there's no question that the US has a lot of responsibility. The US is the single largest contributor to cumulative heat trapping emissions to date, and has been a very uncertain partner on the international stage, has made big promises and then stepped away. So understandably, there is concern from the international community. But what I would say is this is the moment to put pressure on the US to deliver. This is not a moment to walk away and give up on the US, because there's some real important opportunities that we need to lean into here, and policymakers need to feel the pressure from the international arena as well for the US to live up to its responsibilities. I'll stop there.
Thanks, Rachel. Thanks. That's very comprehensive about the domestic landscape and what still is in play. And Michael, why don't you take it from there and let us know what's a good climate advocate to do in the wake of this decision?
Well, I think action is necessary at every level, the federal government, the state level, and the local level. Let me start by saying, as has been noted, the single largest source of greenhouse gas emissions in the United States is transportation. And the new decision from the Supreme Court does not at all affect the ability to reduce transportation emissions. Both the EPA and the Department of Transportation have separate statutory authority to regulate fuel economy and greenhouse gas emissions, and they're doing that. So the Biden administration has put forward important new standards on emissions from passenger cars, and they're working on standards for heavy-duty vehicles. The state of California has special authority under the Clean Air Act to develop its own even stronger rules if EPA approves that, which this EPA I think will do. And California is doing a lot to drive the technology for heavy-duty vehicles, since it controls a lot of fleets of heavy-duty vehicles in California. So on the mobile source front, the motor vehicle front, I think we're in very good shape, and we're hearing a lot of movement toward more electric vehicles because we're facing such high gasoline prices. Those of us who drive electric vehicles, including me, are very happy not to have to pay for gasoline. Electricity is a lot cheaper per mile. We still need to build out the electric vehicle charging infrastructure and do other things. There are a lot of supply chain issues that are unrelated to what the Supreme Court has done, but I think we're moving in the right direction. And the automakers know that. Most of the big automakers have said they are transitioning to electric vehicles. Now, with respect to coal-fired power plants, it's already been alluded to, there are a lot of existing authorities, again, not affected by the Clean Air Act, that allow the government to reduce the use of coal to generate electricity. Coal-fired power plants, of course, release not only carbon dioxide, but they also release conventional pollutants like oxides of nitrogen and particulate matter, and hazardous air pollutants like mercury that EPA has a considerable authority to regulate. Rachel mentioned the ozone rule, the good neighbor rule. There's also something called the regional haze rule. So there are a whole bunch of existing authorities that allow reducing air pollution from coal-fired power plants. Additionally, these plants produce a lot of coal ash. They produce a lot of hot water from the cooling systems, and there are separate statutory authorities that are in the books that, again, are not affected by what the Supreme Court has done, that allow the use of those kinds of tools. We already know that the coal-powered fleet in the United States is sort of dwindling down. One number I saw said that there were at one point 357 coal-fired power plants in the United States. It's now down to 173. Nobody's building any new ones. The old ones are getting older. They are often uneconomical. They're outpriced by wind and solar in many places. Actually, building new wind and solar capacity is cheaper in many places than continuing to operate an old coal-fired power plant. So the question is, what is the pace at which we retire the rest of the fleet of coal-fired power plants? But they're on their way out, and the principal direct effect of that Supreme Court decision is to slow down the pace at which they are retired, but they are retiring. Rachel also talked about the tremendous growth in wind and solar. We've seen globally a plummeting of the price of the cost of those things, and so it becomes much more economical to do it. Where I am in New York, we're seeing a tremendous growth in offshore wind, for example. There are a number of impediments to the construction of many of these facilities, such as local opposition, some supply chain issues, a number of other issues, but that's not affected by the Supreme Court. We also need a massive build out of new transmission lines to carry the power from the utility scale generators where they are, where the power comes from to the load. And there are some emerging laws to make it easier to do that. As we've heard, Congress Congress authorized EPA to regulate hydrofluorocarbons, which are a very powerful greenhouse gas, and there's a lot of work on methane as well. States have a lot of authority here, and state authority is not at all affected by greenhouse gases. Under the Federal Power Act, it's the states that are in charge of the generating facilities, not hydro and nuclear, but for everything else. And so states that want to strictly regulate the fossil fuel generating plants that are in their borders can do that. And a number are. Several of the states have adopted strong climate laws. In New York, we have the Climate Leadership and Community Protection Act. Just a couple of weeks ago, the State Department of Environmental Conservation used that statute to deny the approval of a large natural gas power plant in Queens. Yesterday, the state announced that it was using that law to prevent the resumption of operations of a dirty power plant that was going to be used to fuel a Bitcoin mining operation. Bitcoin is one of these ridiculous energy consumers, the Bitcoin mining, and it's good that at least some states are stepping up and saying, no, we don't want to further get in the way of our efforts to fight climate change by allowing more Bitcoin. And so many states are moving aggressively for more renewable energy facilities. Energy efficiency also has tremendous opportunity. The US Department of Energy has a lot of authority to require energy efficiency in appliances, in industrial equipment, and so forth. They've used some of that, but not all of that. The Department of Energy is moving more in that direction. States can also impose energy efficiency requirements on types of appliances and efficiencies where there are not federal standards. So there's a lot that can be done. Our center at Columbia Law School has a project called Model Laws for Deep Decarbonization in the United States, where we're enlisting pro bono law firms to draft a lot of laws that states and localities can adopt. Let me just say a couple more things. So there was a question in the Q&A, are there any regulations that might be especially vulnerable to this decision? There was mention of the Securities and Exchange Commission proposed rule. I'm sure it'll be attacked on that basis. I'm not saying the attacks are at all valid, but I think actually lawyers for some industries and anti-regulation states are going to be citing this decision all the time, and it's going to be a constant effort to fight back, and not only in the environmental area, but in food and drug and occupational health and a whole lot of other areas. Another thing that's going on where I think people in Europe might play a role is there's a great deal of discussion in the U.S. Congress about the imposition of border carbon adjustments, the idea of charging for the when we are importing goods, imposing a charge that reflects the sort of carbon content of the manufacturer of the goods. But that's got to go two ways. The U.S. can only legitimately impose a carbon border adjustment if we ourselves are controlling greenhouse gas emissions, which we're not doing nearly enough. If you don't have that kind of symmetry, then the World Trade Organization rules might be violated. So I think pointing out strongly the U.S., Europe pointing out to our U.S. trading partners that these border carbon adjustments impose certain perils on what they're doing. Final thing I'll say is, Alden asked, what can a good U.S. climate advocate do? It's been alluded to. If we in the midterm elections, keep the House of Representatives and add a couple more Democratic senators, a lot can be done. We're held up from legislation right now because the U.S. Senate is tied, and two of its members who are nominally Democrats have been blocking action to bust the filibuster rule and allow climate and a lot of other legislation to go forward. So for U.S. climate advocates, I would say right now the most important thing is to become active in some of these congressional races so that the Congress turns out in the right direction. People outside the U.S. can't participate in that; they can't contribute. But for a U.S. climate advocate, I think that's the most important thing to do.
Thank you very much, Michael, and thanks to all of you. We've had a number of questions in the chat and in the Q&A, and just a reminder, if you do have a question, put it in the Q&A section. Let me start with you, Andres. There was a question about whether there's any chance for reversal of this decision. Obviously, there's no higher power than the Supreme Court. I guess there could be a conversion on the road to Damascus, and some of the six in the majority could rethink their views. There's another question in the Q&A from Alex Stapleton, who refers to Section 115 of the Clean Air Act, which allows the EPA to set economy-wide emission reduction standards in the context of similar action by other countries. And maybe you could comment on that. Is that a viable option going forward as well?
Yeah. So I think, Mike, you've done some work on 115? Yeah. I'm gonna let Mike answer the 115 question. As for reversing this decision, so this is a statutory decision, which means it's the Supreme Court interpreting a law that Congress passed rather than something in the U.S. Constitution, which means, in theory, Congress could pass new legislation saying, in fact, EPA does have the authority that the Supreme Court said they don't have. I mean, that would require new legislation. The reality is that's not going to happen anytime soon, unfortunately. Mike alluded to this earlier, but we have a paralyzed legislative process in the United States Congress. To pass most kinds of legislation, there are some major exceptions, which is what Mike was referring to and what Rachel was referring to when they were talking about the reconciliation package. For most pieces of legislation, you need effectively 60 votes out of 100 in the US Senate to actually get something passed. And that is not politically possible for many, many, many things. It sometimes happens. We recently saw, some modest bipartisan gun control legislation passed for the first time in decades. So it can sometimes happen, but there is no realistic way that you're going to find 60 votes in the U.S. Senate to restore the authority that the Supreme Court found that EPA didn't have in this case. So unfortunately, we're not going to be looking at a reversal in this particular issue. And then, Mike, do you want to address 115?
Just Andres, one question before Mike comes in, just for people who are confused about the filibuster versus reconciliation. I'm assuming legislation giving EPA the authority the court stripped away could not be done through the budget reconciliation process, right? Right,
yeah. And just to clarify, the budget reconciliation process is a kind of a unique area in which you don't need 60 votes. You only need 50. And that's also true for nominations. When the US Senate votes on nominations for cabinet positions or ambassadors or judges, they also don't need 60 votes. But the rules of budget reconciliation, and it gets very complicated, there are only certain kinds of things that can go through that process, things that directly affect funding. So that's why Congress can, and right now they are, hopefully negotiating a package that would accord hundreds of billions of dollars to renewable energy and to environmental justice communities and to other things like that. That's utterly critical, that I think that many of us would all agree is the single most important thing that can happen in our government to move climate action forward. But I think that most of us would and I'm not an expert on the specifics of this. I don't think that Congress would be able to put authority, to give EPA this authority that's been lost. It would be very difficult to do it through budget reconciliation.
Thanks. That's what I assumed. Michael, over to you.
Yeah, just a couple of things. One sort of bright spot in the decision that came out is it was not based on constitutional issues. It didn't say that anything that EPA was trying to do or that Congress was trying to do was unconstitutional. There was some concern about that, but they didn't say that. So Congress could fix it. Congress with a simple majority could enact a carbon tax They wouldn't need 60 votes to enact a carbon tax, which is not to say that I think that they will, but they could. And again, if we did have a couple more seats in the Democratic seats in the Senate, they could eliminate the filibuster rule. There's a lot of pressure to do that, not only for environmental grounds, but also on voting rights, on reproductive rights, on stronger gun legislation, and so forth. So if it turns out that way, and there's a stronger Democratic majority, then maybe that'll happen. The current polling doesn't suggest that we'll likely see that, but who knows? Section 115 is a section of the Clean Air Act that would allow EPA or the federal government to make a finding that pollution from the US is causing damage in other countries. And that was initially with the idea that there might be a power plant in northern part of the US that was blowing over into Canada, or in the southern part into Mexico. And so EPA could order that state to control that pollution. We at Columbia and others have worked up theories on how that could be used against climate change. I think the statutory language is very clear that that's allowable. However, I think this too raises a major question. And if EPA were to try it, I think that the same doctrines that they just use on the Clean Power Plan, the current court would also apply to Section 115. So I frankly don't see that happening right now.
Thanks. There's some questions about EPA's ability to use other tools to reduce power plant emissions, such as CCS and co-firing and efficiency. Rachel, maybe you can address that, and maybe you and Andres both can address the question from the retired EPA engineer. Great to have you on the call, Jeff. And thanks for your work in the Obama administration. UCS and Sierra Club were both very involved in those regulations back in the day. Maybe you can both address the question about the application to vehicles standards. So Rachel, maybe first start on what EPA can do on power plants, and then both of you can weigh in on the vehicles question.
Yeah, so in terms of the power plant reg, so it's a little premature to speculate too much on what EPA will do. They clearly have absorbed yesterday's decision and need to go to the drawing board. But we've heard Michael Reagan, EPA administrator, speak of things like installing renewables within the fence line of facilities, existing fossil-fired facilities. Everything is on the table clearly, and they are going to want to use every tool in their toolbox. The critical thing to understand here is how EPA sets standards, and then how utilities and states implement them. So what the Supreme Court did was hamstring how EPA can set standards in terms of how it can determine the best system of emissions reduction. They said that EPA cannot do what they did with the original Clean Power Plan and take the sector-wide, system-wide approach. They have to go to the individual facility, the individual electric generation unit. So if the EPA determines something like CCS is DSCR, absolutely, they can use it to set a standard. That does not mean that any utility has to install CCS or that states have to take that route. It just means that the pollution standard can be set at that level. And then how you meet it, that's up to you. You can decide it's cheaper, better for the environment, better for communities to do it through installing wind and solar and turning down fossil fuels, and that would be just fine. So this is a critical piece to understand how EPA sets the standards and then how it gets implemented. The other piece around this is just noting that with the original Clean Power Plan, we've already more than exceeded its goals well ahead of time. And that's because of market trends that are making things cheaper. And if we get these clean energy tax credits in Congress, that greases the wheels even more. We can get more renewables on board more quickly. And so it's in that context that any standard that gets set can be not just met, but exceeded. And that's the world we're pushing for right now. In terms of the question about the vehicles regulations, so yesterday's decision was very narrow, and they were very clear about that in the decision, that this was about power plants and this was about the Clean Power Plan specifically and some of its provisions. And that's important because this was not the most damaging version of a decision we could see, which would have been things like undermining GHG authority, speaking more broadly about other sectors of the economy. So based on yesterday's decision, there was nothing in there that would directly attack vehicle standards. That said, as Andres pointed out, the implications are sobering, and you can imagine that bad actors will continue to challenge a whole range of regulations, not just around GHGs. The critical distinction, though, with vehicles is if the private sector gets in the game, which we're hearing that many car companies, not all, are wanting to be in this game. They're actually trying to shift their production lines. They see it as a global competitive issue to have more electric vehicles. And that just changes the context in which any regulations happen. So we've seen the car industry flip-flop when the Obama administration was there and then when the Trump administration came in. So need to be wary of that. But the trend overall seems to be that more and more car manufacturers are understanding that this is where the future is.
Thanks.
Yeah.
Andres, do you want to come in on that anymore?
Yeah, sure. I think that's all right. I think Rachel's point about buy-in from industry is critical here. I will say this. I think Mike hit the nail on the head when he said that it's really difficult to know how courts are actually going to rule in future cases on major questions, but I think we can be certain that we're going to see industry raising these arguments all the time. So I think that if, and this is the question from, was it from Jeff, if they set really stringent NOx and PM standards, if those standards for cars really did reflect available technology, then that really would in no way run afoul of the decision here. But I think that if they did that, there would at least be some, some litigants, not necessarily, even if most of the industry had buy-in here, sometimes you get individual manufacturers that try to get, involved. Sometimes the way that our system is set up sometimes allows other entities, potentially oil manufacturers, if they could show that they had a stake in this, I'm not saying it's certain that they would be able to, but if they were able to show they had a stake in this, they could get involved in litigation and bring these challenges. So I think that it's likely that we would see those challenges, but whether they're successful or not is much more of an open question. One other kind of bright spot or in all of this is that a lot of federal regulations and certainly Clean Air Act regulations go to the DC Circuit. That's the U.S. Court of Appeals for the District of Columbia, which is sometimes referred to as the second highest court in the land. It's actually not any higher than any other courts of appeals, but it is a very influential court, especially on issues of administrative law. And so Clean Air Act regulations, when they go into litigation, the first stop is generally going to be the DC Circuit. And that happens to be a court that was not, the Trump administration, they did appoint some judges to it, but they didn't change the fundamental makeup of that court. And it still is, the majority of those judges on that court were appointed by Democratic presidents. And they're very, very smart judges. A lot of them end up going to the Supreme Court. And, that means that litigants are not going to be able to shop around in many instances and try to find a court that they think is going to have the kinds of judges that are most likely to grant a very broad major questions ruling. Now, sometimes they can do that. And we've seen that happen in a number of cases. But I think that one of the things that comforts me is that we do have, generally speaking, a DC Circuit that I think is not going to expand this doctrine. That they're going to interpret it as, likely relatively narrow. And, the Supreme Court can always overrule that, but there's only so many cases that the Supreme Court can take. And maybe they're going to just say, who cares and strike one thing down after the other, but it takes a long time. And so it's, again, it was definitely a bad decision. The major questions component really was not at all helpful to us, but it's also not necessarily the death knell for regulations. I do think that we're still going to see things happen. And then last point I'll make, what I think that is likely to happen, when I look at this landscape of EPA regulations now, the Clean Power Plant style approach, it was definitely a more creative interpretation of this provision. I think a lot of the other regulations that we see that are important are much more traditional in how they approach regulatory issues, whether it be the oil and gas methane regulations or some of the non-greenhouse gas regulations that Mike mentioned, like regarding the cross-state transfer of transport of ozone and things like that. I think that a lot of those, because they are more traditionally how EPA has adopted these questions, are less likely to fall within major questions purview. But it does mean that I think EPA is probably going to be hesitant to take more creative approaches on other things that it hasn't yet regulated. And that's something that, it's definitely a concern, because we've got a Congress that has a really difficult time acting. We do have some really powerful legislation on the books, but if the court is going to say EPA really does not have much leeway to interpret this in sort of creative or non-traditional ways that would have a big impact, that is going to maybe put the brakes on some of the things that they otherwise would have done in other areas. So we don't have a crystal ball. We can't say for certain. I don't think we're going to see a ton of rules and regulations and safeguards that are currently now in effect being vacated left and right. But I do think the agency is going to be thinking twice about taking certain bolder actions into other areas that they may otherwise would have done without this decision.
Yeah, I think that's absolutely right. The reluctance to use Section 115 is one example of that, but I think this decision is going to have a deterrent effect, a dampening effect on a lot of agencies across the government. Just a couple of quick things. It's absolutely right that the DC Circuit is the key court below the Supreme Court here, and it still has a Democratic majority, but the decisions are made by 3-judge panels that are randomly selected. And if you have a panel that has a majority of Republicans, it may go the wrong way. And so that's a concern.
True. That's true.
Sort of another interesting issue is looking at who actually sues in the Clean Power Plan case. The lawyer for the power industry argued in favor of the Clean Power Plan. It was the coal companies and the coal states that were opposing it. Back in 2010, when EPA imposed greenhouse gas standards on motor vehicles, the motor vehicle manufacturers didn't sue. Again, it was various anti-regulatory interests, so all of these are interests that want more use of coal and more use of oil, but the actual manufacturers of the automobiles and the users of coal at power plants, the utilities, have tended to be okay with the rules and don't challenge them.
Thanks a lot. And Rachel, we've got a few minutes left. Let me ask you to go a little deeper on the international obligations and the effect on the US NDC. I mean, the analysis I've seen from UCS, from Rhodium, from others says that we have to go pedal to the metal on every tool available: state and local action, regulatory action, congressional action, et cetera, if we're going to have a chance of meeting that 50 to 52%. And you and I know and agree that that may not be the entire US fair share of what we should be doing, but it's an incredibly ambitious stretch goal that requires all hands on deck. What is your assessment of the impact of this ruling on our ability to get to that 50 to 52% or even close?
Yeah, I think the most direct answer is it's not this ruling alone, although the ruling is deeply concerning. It is the context that the international community is seeing. They're seeing our Congress unable to move. They're seeing the Supreme Court decision. They're seeing, frankly, worrying signs with our response to the war in Ukraine and how both Europe and the US have struggled to chart a path that is both compatible with a climate safe future, as well as making sure that we're not taking these detours to double down on fossil fuel infrastructure in response to this unjust war. So this struggle is happening not just in the US, it is, watching some of the developments in Europe, including the latest G7, which did not have a very ambitious outcome. These are troubling signs, and it also gives cover to bad actors. So that is really important. The US living up to its responsibilities is about the US, which is a big emitter, but it's also about persuading, cajoling, engaging in diplomacy with other major emitters like China, like India, to do more. And we are now in a very hampered position by not being able to deliver here domestically thus far. We're not in a position to do any of that cajoling with others. So it's a worrisome sign, and this year, as we go towards the international climate talks in Egypt at COP27, this lack of delivery in the context of the latest IPCC reports, which have sounded a dire alarm, we're just not living up to what the science shows is necessary. We're also not delivering on climate finance yet. We need to be appropriating the climate finance to help low-income countries make this clean energy transition, invest in climate resilience, and the US has been a blocker on loss and damage as well. So, the international community is a little frustrated with the US posture right now, and I think we have a lot of work to do cleaning up in the next few months. I will say my fervent hope is that we will get a bill out of Congress. It's not dead yet. I hope that they will deliver by the time we get to COP.
Thanks. Yeah, I mean, I think that's right. I've been in this process over 30 years, and the US is like Lucy with the football in Peanuts, pulling the football away at the last minute from Charlie Brown every time. First, we made sure that the original Rio Treaty had no binding commitments. Then we forced our way on the design of the Kyoto Protocol, but didn't ratify and enter into it, partly because of a disinformation campaign by the fossil fuel companies. Then, of course, we had the Bush years declaring Kyoto dead, which hopefully the rest of the world did not take his advice and carried on. And then, of course, we had Trump withdraw from Paris, and now this. So the world is getting tired of this. And of course, one of the dynamics is on the second day of COP27 in Sharm el-Sheikh, we'll have the midterm elections. And of course, there's a lot of concern about what it means if the Republicans take the House and/or Senate, given the current stance of the majority of the party. So that's another uncertainty hanging over this whole process. And the finance piece is essential. I mean, the US has underdelivered on climate finance relative to the European Union, Japan, and other developed countries. And unfortunately, there are not, at least now, signs that Congress will step up to the plate and deliver the $11 billion request the administration just made for its FY23 budget. So there's a lot of grounds for concern here, but this has been a tremendous panel.
Hey, Alden,
very informative. Yep, you want to come in, Andres?
very quickly. I know we don't have much time, but there's a really insightful question from Jacob that I just wanted to very briefly address. He asked is it possible that if EPA starts relying more heavily on health-based regulations as opposed to climate-specific ones, is there a chance of legal risks or backlash? Certainly political backlash, but there always is. I mean, any regulations, that are aggressive, there will be backlash. I can tell you that EPA, I know, is very smart about this and very aware of this issue, and the staff at EPA is very careful to make sure that their health-based rules for power plants and for other sectors that Mike mentioned a bunch of them earlier, that they are not seen as, climate regulations smuggled in through the guise of health regulations. Those are all very carefully justified based on health concerns. And they're all very, not just through sleight of hand, but all legitimately based on health concerns. So I'm not too worried about that angle, just because I know that the administration is very careful about this and are very likely to have a very robust administrative record in support of any of those health-based regulations.
Great. And let me just see if Michael or Rachel have any closing comments you might want to make before we wrap this up.
Well, I'll just say that I agree with all hands on deck, that there needs to be action at the federal level, the state level, the local level. There's a lot the private sector can do. There's a lot that the civil society can do. Everybody has to do as much as they possibly can.
Yeah, maybe I'll just say in closing, what you've heard today is sort of a very dire landscape on the politics. The science does not bend to the politics. The scientific imperative, the reality of accelerating climate impacts, the rapidly narrowing window we have to act, this is all crystal clear. So regardless of what the court did yesterday, regardless of our dysfunctional Congress, those realities are what the American people and people around the world are and will be facing. So the question now is, are we going to radically transform our world through climate change, or are we going to be willing to lean into transformative action to address it? Either way, we're talking about transformation. The question is, do we want to grab this and make the proactive steps that we need to take to help protect people on the planet, Or are we just going to allow the kind of dangerous transformation that's already underway through climate change?
Well, thanks to all three of you. This has been a great conversation, and thanks to everyone who put questions in the chat. And just a reminder, this has been live streamed, and it will be on the E3G website if you want to refer colleagues to watch it at their leisure. But thank you again, Andres and Michael and Rachel, and thanks to Will and others at E3G for setting this up today.
Thank you all.
Thank you very much.